For Title I specifically, which focuses on the employment context, it is enforced by the Equal Employment Opportunity Commission. Title I is an anti discrimination statute that requires that individuals with disabilities be given the same consideration for employment that an individual without disabilities would be given. Now, employers that are under or that are subject to Title I are those that have 15 or more employees. And so businesses that do fall within the scope of ADA are required to provide reasonable accommodation so that an individual with a disability may perform the required tasks of their job. Now, when it comes to discrimination and accommodation within the employment context, we're talking about, the application and interview process, hiring, job assignments, job evaluation, promotion, termination, compensation, training, disciplinary action, service opportunities, conditions of your employment. We're talking everything related to the employment context if you weren't picking up on that. And so under ADA, it requires that businesses provide reasonable accommodation. This is any modification or adjustment to a job or the work environment that would enable a qualified applicant or employee with a disability to participate in the job process and perform the essential job functions. Reasonable accommodations that you can see at the bottom of your screen often include facility access, restructuring job tasks, modifying work schedules, potentially providing readers or special computers, interpreters, all examples that you can see on the graphics on this slide. Now, reasonable accommodations are required unless they would create an undue hardship on the employer. So an undue hardship is really any action that would require significant difficulty or expense. And so the courts will consider, the nature and cost of the accommodation and weigh it against the overall financial resources of the agency, the size, budget, profitability of the business, and the potential financial impact of the accommodation. And so they'll weigh those against each other to see if it would be considered reasonable. But a few examples, or actually here are a few examples of what would be unreasonable, just so you have some context. Eliminating an essential important job function from a job position would be considered unreasonable. Having lower production standards for one employee compared to another employee would be unreasonable. Making arrangements that just conflict with the company's seniority system would be considered unreasonable. Having to provide specific items for daily activities that are of a great expense would be unreasonable. Those are just different examples, but most accommodations, which we'll talk about, are reasonable. Few defenses to discrimination for us to consider. Now, we've already brought up undue hardship, and I wanted to add a little bit more context here. Undue hardship is a viable defense for ADA Title I, which is the employment context, or Title II, which is public services. It doesn't exactly pertain to Title III. We'll also talk about Title III in a minute. So undue hardship, it's focusing on any action that requires significant difficulty or expense. And so courts will examine the nature and cost of the accommodation required, and then the expense that would place on the business. But they'll also consider, well, what resources does the business have? How large is the business? What would the overall impact be? Under Title II, the public entity is required to make reasonable modifications unless that service provider can demonstrate that doing so would either be an undue hardship or potentially fundamentally alter the nature of the service program or activity provided. Um, so I wanted to highlight a couple of graphics on this screen. First of all, research shows that the majority of accommodations requested from individuals with disability have zero cost, zero cost. So undue hardship is rarely a viable defense. And as you can see, when there are accommodations with cost, the median cost is $500 one-time cost. I just really wanted to draw your attention to we should make all efforts to make reasonable accommodations. Often we'll see accommodations be unreasonable when it comes to the, adjusting the infrastructure of a building. Um, Maybe you can avoid that and focus on other ways to accommodate an individual, such as if someone has a physical impairment, their office space is on the first floor. If you don't have an elevator in an old building, or you allow a service animal, or there are so many ways to accommodate without incurring a large cost. And then when it comes to fundamentally altering the nature of what is offered, we had previously discussed what would be unreasonable in the employment context, such as lowering production standards for someone with a disability versus someone without a disability. But we'll also see this in Title II when it comes to athletics. If you need to fundamentally alter the nature of a sport in order to accommodate an athlete with a disability, you do have a viable reason to not accommodate, and that could be used as a defense. On the screen, you'll just see an individual playing wheelchair basketball. Now, that's an option is to create an adaptive sport for individuals who cannot accommodate. But when it comes to athletes who are requesting to participate in your school's sport, for example, um, ideally, we are to pursue inclusive, universal design for our programs. The best practice standard is to provide full equal access to those athletic opportunities. But you must consider the safety of the individual and whether they are qualified individual with a disability, whether they can participate safely. You are not required to fundamentally alter the nature of the sport in terms of changing the rules. For example, changing the requirements. If you have a tryout, changing the standards for one athlete as opposed to the rest of the team, that would be considered unreasonable. But there are so many ways to provide reasonable accommodation. I was reading a case the other day of an athlete who was hearing impaired, who was a wrestler and had a translator stand outside the mat and follow the wrestler in his line of sight so that they could translate any of the calls of the official, for example. So there are just so many ways to provide accommodations to increase access for individuals with disabilities. And then this last defense on this slide is a direct threat. And I want us to focus on this bottom picture for the direct threat, which we often see in relation to Title III. So a direct threat exception can be raised as a defense when there is concern about the health or safety of others, given the nature of the person's disability or due to the auxiliary aid that a person uses, such as a wheelchair. Direct threat is often an issue in the context of emergency evacuation of people with disabilities. And so when you see in stadiums accommodations for individuals who are wheelchair bound, for example, like on this picture, you'll see a area for that individual to sit and watch the game. You'll notice that often there are not places for individuals with a wheelchair to sit courtside, for example, because there are concerns regarding the evacuation of that person that efficiently and their safety. And so in these types of situations, safety of the individual with a disability and safety of those around them, can you efficiently evacuate people from a facility, will be considered And so sometimes, unfortunately, we're not able to provide full and equal access um, to an experience such as a sport event if it may create a direct threat to that individual or the individuals around them. So the placement of handicap seating is, I would say, one of the best examples that I can give you here. And my boss, who I had mentioned previously, who's visually impaired, so he requests accessible seating so that his service animal Kate can join him. And he was also sharing frustrations because he has to pay an upcharge for accessible seating, but he doesn't even have access to court seating because that's not provided because of this direct threat exception. And it's just, he's given me a lot of helpful insight over the years.
So though that is a quick review of all of the relevant federal laws that pertain to employment discrimination. I kind of wanted to pull this all together for us in terms of burden of proof. So this is the order of burden of proof if you were to file a complaint with the EEOC. If you are an applicant for a position, you need to prove that you are a member of a protected class, that you applied for a job for which the employer is seeking applicants, you are qualified to perform this job, you were not hired, and the employer continues to seek applicants after your rejection. But when you're proving that you are not hired, you have to prove you are not hired because you are a part of a protected class. So that's an important piece. And there was discrimination involved. If you are an employee, so once again, you do need to prove that you are a member of a protected class, you were performing your job satisfactorily, and you were discharged or adversely affected in your work conditions, and your work was assigned to someone else. So that is what you need to prove. You're a member of a protected class, and you need to demonstrate the discriminatory employment practice. And then the burden of proof will shift to the defense, who must prove that the alleged discriminatory employment practice was for a legitimate, non-discriminatory reason. So you need to have a clear justification for your employment practice, which, for example, in the US women's soccer complaint, we saw that the US Soccer Federation was able to demonstrate a justifiable defense through the collective bargaining agreement. If the defendant is able to provide a legitimate non-discriminatory reason, the burden of proof will once again shift back to the plaintiff. And it is at this time that you need to prove, or the plaintiff, that this legitimate reason is actually pretense for intentional discrimination. And you can do this in a few different ways. You can provide direct evidence of prejudice toward either the plaintiff yourself or other members of the protected class. So direct, hard proof evidence. Present statistical evidence to show, just from a statistics standpoint, how members of a protected class are being treated differently in terms of work conditions, compensation. So stats, always a great way to build up your evidence. Or present comparative evidence that members of a protected class are treated less favorably to members of another class. So honestly, just it's up to you to not only prove the discriminatory employment practice, but to back it up with evidence to show differential treatment in the employment context. And then once again, the burden of proof would shift back to the defendant, who would need to prove that the plaintiff's evidence basically lacks merit. So it's a bit of a back and forth game, but you're trying to prove discriminatory employment practice if you're the plaintiff with evidence of that discrimination, and the defense is trying to prove a legitimate justification for that employment practice. So if there is a complaint that is filed, there are several defenses that employers can think that they can use or take into consideration. So we're going to go through a few of those. The first one is a bona fide occupational qualification. So the BFOQ defense requires that the employer prove that members of the excluded class could not safely or effectively perform essential job duties. Now, the employer must have a factual basis for believing that persons in the excluded class could not perform the job. It must be something that is reasonably necessary to the normal operations of business. So this expectation, what is this like performance of job duties? It needs to be necessary to the normal operations of the business. An example of a bona fide occupational qualification would be pertaining to religion as a protected class. My parents, Dave and Pat Lauer, work for a Christian organization called Athletes in Action. It is a sports ministry whose primary purpose is to share this faith with others through sport. And so within their application process, they have a requirement that the applicants observe the Christian faith that the organization is based on. And it is considered a bona fide occupational qualification because in order to perform the job duties within that organization, which is to further this faith, it is reasonably necessary that the employees observe that faith. So that would be an example of a BFOQ. However, race and color are never, ever bona fide occupational qualifications. Just wanted to point that out. Business necessity is fairly similar to BFOQ. For a business necessity, the employer has to prove that a particular practice is job related. And therefore it's a business necessity, it just might have a discriminatory impact on a particular group of people. So with business necessities, I often think of gender discrimination and certain manual labor jobs that might require certain physical ability. It could potentially have an adverse effect on women who are anatomically different from men. However, if the physical skill or qualifications or strength is necessary to perform the job, then the employer could cite business necessity for that qualification. And then seniority system is also a defense that can be used, and we often see seniority system for the hiring and promotion process. And this essentially recognizes job tenure and will allocate opportunities based upon that. So the longer that you're in your work, the more likely that you have an opportunity for promotion or a job reallocation and just different employment opportunities because of your time spent there. So seniority system can also be a justification for providing certain employment benefits to groups of people over other groups of people. And then a few other defenses for us to consider is the merit system. So the merit system and system based on quality or quantity of production, I see those as kind of going hand in hand. And this is essentially when applicants are hired or employees are promoted based upon their performance, right? Based upon their quality and quantity of production is justification and merit for receiving employment opportunities and benefits. Another defense that we will see is affirmative action. An affirmative action involves creating policies that give preference to those who are underrepresented in the workplace. And it really changes based upon your industry. So pay attention to your industry in terms of, are those underrepresented, those who are minorities based on gender, minorities based upon their race or color or national origin. But these affirmative action initiatives are intended to increase the diversity of your workplace. And they are legal if the program is formal and systematic, it's temporary and operating until its goal of increasing the percentage of underrepresented workers is met in order to rectify past discrimination, The program is legal if it doesn't bar an employer from hiring or promoting a non-minority individual. It's legal if the program does not result in the firing of a non-minority worker. And it's legal if the program does not force the employer to hire or promote an unqualified worker. So essentially, this program is legal when if a minority applicant and a non-minority applicant with equivalent qualifications were to apply to a job, the employer chose the minority applicant based upon a formal affirmative action program to increase the underrepresentation of that minority group in their workforce. But it shouldn't have adverse effects on non-minorities, just so you know. And you need to still hire the most qualified person. And then another defense is reduction in workforce. So essentially, if an employee is let go because of a layoff in regards to cost-cutting measures and not because of their race specifically. And please note that that employee is not replaced. It is just a layoff to reduce the workforce most of the time for budgetary reasons, can be a legitimate defense. And then lastly is our catch-all. Any factor other than their protected classification. If you can prove your employment practice was for any other reason other than their protected class, so their age, their gender, their race, ethnicity, things of that nature, that would be a viable defense. However, if your defense does not land, if the employer is found liable for employment discrimination, there are a number of different remedies that the courts can adopt. And on this slide, you'll see just a list of what is available to the plaintiff. The first one is called a non-discriminatory placement. So when the EEOC finds that an employee was discriminated against, they can require the employer to provide that individual with the position that they should have occupied if they weren't discriminated against, or the position that they sought, or a substantially equivalent position. And it may come with back pay potentially. So back pay, the purpose of back pay is to restore the injured party, so the plaintiff, the income that they would have earned if it weren't for the discrimination. And it may include lost wages or benefits that would have been earned were it not for the discrimination. So that reinstatement can come with back pay. The plaintiff could potentially receive front pay. So front pay is an equitable remedy that compensates an individual when reinstatement to a position is not possible based on certain circumstances. So if reinstatement is not possible because the position is not available, or because a subsequent working relationship between the employer and the employee would be antagonistic, so basically not to the benefit of anyone, or the employer has a record of long-term resistance to anti-discrimination efforts, basically like they are not going to create a position or allow you to pursue an alternative position, then the courts will provide front pay, which is pay for loss of future wages that you didn't have access to. There are other forms of equitable relief, such as potentially canceling an adverse employment action that impacts the status of the employee or the applicant. Also providing the applicant or employee the full opportunities to benefit from their employment that was denied. So this could be providing training, preferential work assignments, overtime scheduling, any benefits that they were denied. And then lastly, there is also compensatory damages that are available. So if a plaintiff is able to establish unlawful employment discrimination, in addition to the equitable remedies that were just described, so reinstatement, back pay, front pay, the plaintiff can potentially get compensatory damages as well for past or future losses. So past losses would be like pocket expenses, attorney fees, things like that. And then future losses might be pain and suffering or mental anguish from your experience of employment discrimination. So compensatory damages are also available to the plaintiff. And to conclude, I'd love to leave you with this thought process. On the screen, you will see a number of employment practices listed, and in our industry, we are continuing to see increased momentum and attention paid to addressing justice, equity, diversity, and inclusion. It's so important, and I encourage you to consider how you can promote justice, equity, diversity, and inclusion through these employment practices while you are in the industry as a sport manager. So how can we rectify past employment discrimination and increase opportunities for protected minority classifications and groups of people?